chair calls Karl Hayes.
Mr. Chair, my name is Karl Hayes. I'm here on behalf of the Texas Family Law Foundation. Originally, it is marked down that we were opposed. I'd like to change that. We are in support of this particular bill, which is 1345.
So you want us to change you from being shown against to far?
Yes.
And we can do that with your permission?
Yes.
Okay.
We'd like that.
Go ahead.
We are in favor of the bill and the change that it is proposing to 153.073A of the Texas Family Code. We'd like to make sure that we can touch base with the author on this to make sure that the bill doesn't inadvertently cut off rights that people have anyway. Representative Bowers, one of the problem that we've been having is, just like the previous speaker was talking about, sometimes parents will go have lunch with their kids, and the other parent will get into an argument because that's supposedly not a school activity. And so it's amazing, but people will fight about that sort of thing. Or a field trip, saying, well, that's not exactly a school activity. School activities are plays or they're concerts. And so there's a need, because a parent has a right to go do that. They have a right to go to the football games. They have a right to go see their child at taekwondo or dance lessons when it's not their day to have possession. And we need to make sure that the law specifically provides for that, just to limit the amount of fights that people have about these nonsensical kind of issues. And so we applaud Representative Toth for doing this, and we're fully in support of the bill.
Does the school prohibit the parent from attending some of these activities?
They don't, but the schools are put into the middle of this. And what happens...
So the school doesn't prevent it, but the other parent prevents it.
And sometimes it depends on just how strongly the other parent complains. And
so I'm just trying to understand. So the parent would go and complain to the school, and the school would not. The school wouldn't let the other parent.
Sometimes they do, because the parent goes up there with a court order and says, this is my day of possession, he's not supposed to be up here, or she's not supposed to be up here. And then the school, they're caught in the middle.
Right. And
they'll say, okay, well, we've got the, and then you have to get enough, you're having to try and convince the principal of the school or the school counselor that your client has a right to go up there and have lunch, which they do. The law says they do. You have a right unless there's some order that prevents you from having access to your child. You have a right to access at any time.
So if this bill passes, how would that change? How would they change it?
It changes it by specifying and putting in there school lunches.
But how would the school know it's in here?
It'll be in a court order.
So the father presumably would have to show up at the school with the court order?
If there was a complaint, he'd be able to say, because all of these provisions that are in 153.073 actually end up in a divorce decree that say a parent at all times end up with these rights. And so it'll specifically say the right to attend school activities, including school lunches, performances, and field trips. We want to work with Representative Toth just to make sure that someone doesn't then say, well, those are the only things.
I understand, but the school would have to, presumably, the school would have to honor the court order.
Yes.
Okay. And there's not been a question about the school doing that.
Usually when it's something clear, most of the time in my experience, they'll follow the order, but you have to make it clear because they're laymen. And they don't really, their job is not to interpret court orders.
And then they don't want to get involved in a dispute between the two parents.
Yes, sir.
Yeah. Okay. All right. Okay. I think we got it.
All right. Thank you.
All right. Thank you, Mr. Hayes, for being here.